उसके बाद हमारा माल बिक पाएगा।
भारतीय नागरिक सुरक्षा संहिता 2023 Section 297 sentence on offender already sentenced for another offence by a different court. What this section is about. Section 297 explains how sentencing is to be handled when an offender is already serving a sentence imposed by one court and is later convicted by another court. It ensures coordination between different courts and clarity in execution of sentences. In simple English, if a person is already serving a sentence of imprisonment passed by one court and is convicted and sentenced again by another court, then the later court may order that the new sentence shall run concurrently with the earlier sentence, or the new sentence shall start after the earlier sentence ends, consecutive. Life imprisonment rule. If the offender is already undergoing life imprisonment, any subsequent sentence of imprisonment runs concurrently with the life sentence. Key points of Section 297 applies when sentences are passed by different courts. Court has discretion to order concurrent or consecutive sentences. Default rule is consecutive unless otherwise ordered. Life imprisonment always runs concurrently. Ensures orderly execution of sentences. Why this section is important. Prevents conflict between court orders. Ensures clarity in multi-court convictions. Gives flexibility to ensure just punishment. Avoids meaningless extension of life sentences. In short, Section 297 provides that when an offender already sentenced by one court is again convicted by another court, the later court may order the sentences to run concurrently or consecutively, with life imprisonment always running concurrently. Section 298 Imprisonment or detention to commence after expiration of previous sentence. What this section is about. Section 298 clarifies when a new sentence of imprisonment or detention will begin if a person is already undergoing another sentence. It mainly deals with the starting point of the later sentence. In simple English, if a person is already serving a sentence of imprisonment or detention and is sentenced again to imprisonment or detention, then the new sentence will begin only after the earlier sentence is completed, unless the court specifically orders the sentences to run concurrently. So, the default rule is consecutive sentences, one after another. But the court has the power to order concurrency where the law allows. Key points of Section 298 applies when a person is already in custody. Default rule. New sentence starts after earlier one ends. Court may order concurrent sentences. Ensures clarity in commencement of sentences. Prevents confusion in prison administration. Why this section is important. Ensures certainty and legality in execution of multiple sentences. Prevents overlapping or unclear sentence periods. Helps prison authorities calculate actual term of imprisonment. Supports fair and orderly criminal justice administration. In short, Section 298 provides that when a person already undergoing imprisonment or detention is sentenced again, the later sentence shall commence after the earlier one ends, unless the court orders otherwise. Section 299 Record of previous conviction. What this section is about. Section 299 explains how and when a previous conviction of an accused person is to be recorded during criminal proceedings. Its main purpose is to ensure fairness so that the accused is not prejudiced during trial. In simple English, if an accused person has a previous conviction, that previous conviction shall not be mentioned or recorded at the trial stage while deciding guilt for the present offence. The court must first decide the present case on its own merits. Only after the accused is found guilty in the present case, then the court may record and consider the previous conviction, only for the purpose of awarding enhanced punishment if the law allows. The accused must be informed of the previous conviction and given an opportunity to admit or deny it. Key points of Section 299. Previous conviction is not disclosed during trial. Prevents bias or prejudice. Considered only after conviction. Used mainly for enhanced punishment. Accused has a right to contest the previous conviction. Why this section is important? Ensures a fair trial. Prevents the judge from being influenced by past conduct. Protects the principle that each case must be decided independently. Balances fairness with habitual offender provisions. In short, Section 299 provides that a previous conviction shall be recorded and considered only after the accused is convicted in the present case, and only for the purpose of enhanced punishment after giving the accused a fair opportunity to respond. Section 300 bar to second trial, protection against double jeopardy. What this section is about? Section 300 embodies the principle of double jeopardy, that no person should be tried or punished twice for the same offense once a court has finally decided the case. In simple English, if a person has been tried by a competent court and convicted or acquitted of an offense, then he cannot be tried again for the same offense or any other offense based on the same facts, for which a different charge could have been made at the first trial. Important conditions. The earlier conviction or acquittal must still be in force, not set aside. The first trial must have been by a court having proper jurisdiction. Exceptions when second trial is allowed. A second trial may be permitted if the previous case was withdrawn or dismissed without a decision on merits. The law specifically allows a fresh trial. The offense is distinct and separate, even if facts are related. Key points of Section 300. Applies after conviction or acquittal. Protects against double punishment. Covers offenses based on same facts. Earlier trial must be by a competent court. Reflects constitutional protection. Why this section is important? Upholds fairness and finality in criminal trials. Prevents harassment through repeated prosecutions. Protects Article 22 of the Constitution of India. Ensures confidence in the criminal justice system. In short, Section 300 provides that once a person is tried and convicted or acquitted by a competent court, he cannot be tried again for the same offense or on the same facts, except in cases expressly permitted by law. Section 301 Appearance by public prosecutors. What this section is about? Section 301 explains who is allowed to conduct prosecution in criminal courts and how private lawyers may assist the prosecution. It clearly defines the role and authority of the public prosecutor. In simple English, in every criminal case, the public prosecutor, PP, or Assistant Public Prosecutor, AP, has the exclusive right to conduct the prosecution in court. Role of a private lawyer. if a private person, complainant or victim engages a lawyer. That private lawyer cannot independently conduct the prosecution, but may assist the public prosecutor. Such private lawyer acts under the directions of the public prosecutor and may submit written arguments only with the permission of the court. Key points of Section 301. Prosecution is conducted only by PP app. Private counsel can assist, not replace, the PP. Assistance is subject to PP's control. Written arguments need court's permission. Ensures uniform and fair prosecution. Why this section is important? Maintains objectivity in criminal prosecution. Prevents prosecutions driven by private vengeance. Ensures the state remains the primary prosecuting authority. Protects accused from multiple or conflicting prosecutions. In short, Section 301 provides that prosecution in criminal cases shall be conducted by the public prosecutor, and any private advocate may only assist the prosecution under the public prosecutor's directions with court permission. Section 302 Permission to conduct prosecution by a private person. What this section is about? Section 302 explains when a private person, complainant or victim can be permitted to conduct the prosecution himself instead of the public prosecutor. This section is mainly relevant in magistrate courts. In simple English, in a case before a magistrate, the magistrate may permit a private person, such as the complainant or victim, to conduct the prosecution himself or conduct it through a lawyer engaged by him. Important restriction. This permission cannot be given in cases where the offence is triable exclusively by the Court of Session. So, allowed magistrate tribal cases. Not allowed sessions tribal cases. Key points of Section 302. Applies only to magistrate courts. Court permission is mandatory. Private person may conduct prosecution. Sessions court cases are excluded. Magistrate has judicial discretion. Difference from Section 301. Section 301 Private lawyer can only assist the public prosecutor. Section 302 Private person can directly conduct prosecution, but only with magistrate's permission. Why this section is important? Empowers victims and complainants. Useful in private complaint cases. Ensures flexibility where state prosecution may be minimal. Still protects fairness through court control. In short, Section 302 allows a magistrate to permit a private person to conduct the prosecution in magistrate tribal cases, but this permission cannot be granted for sessions tribal offences. Section 303 Right of the accused to be defended by a pleader of his choice. What this section is about? Section 303 guarantees the fundamental right of an accused person to be defended by a lawyer, pleader, of his own choice in any criminal proceeding. In simple English, in every criminal case, the accused has the right to engage a lawyer of his choice and be defended by that lawyer at all stages of the proceedings. This right applies from the beginning of the case and continues throughout trial, appeal, and other proceedings. Key points of Section 303. Applies to all criminal proceedings. Accused may choose any qualified pleader. Right belongs to the accused, not the court or state. Ensures effective legal representation. Part of a fair trial guarantee. Why this section is important? Protects the right to a fair trial. ensures equality between prosecution and defense, helps the accused properly understand and answer charges, reflects Article 22(1) of the Constitution of India. In short, Section 303 provides that every accused person has the right to be defended by a pleader of his own choice in any criminal proceeding. Section 304, Legal aid to accused at state expense. What this section is about. Section 304 provides for free legal aid to an accused person who cannot afford a lawyer. It ensures that lack of money does not prevent a fair trial. In simple English, if an accused person is not represented by a lawyer and does not have sufficient means to hire one, then the court must provide a lawyer at the expense of the state. This applies especially in trials before the Court of Session and other serious criminal proceedings where legal representation is necessary. The court must inform the accused of his right to free legal aid and appoint a competent pleader for his defense. Key points of Section 304 applies when accused cannot afford a lawyer. Legal aid is provided at state expense. Court has a duty to inform the accused, especially important in sessions trials. Lawyer must be competent and effective. Why this section is important. Ensures equal justice for rich and poor. Prevents unfair convictions due to lack of defense. Strengthens the right to a fair trial. Reflects Articles 21 and 39A of the Constitution of India. In short, Section 304 mandates that if an accused cannot afford a lawyer, the court must provide free legal aid at the expense of the state to ensure a fair trial. Section 305, Procedure when a corporation or company is an accused. What this section is about. Section 305 explains how a legal entity, like a company or corporation, can be prosecuted in criminal cases since a company itself cannot appear in person. In simple English, if a corporation, company, or other body is accused of a criminal offense, the court cannot summon the company itself because it is not a natural person. Instead, the officers, directors, or authorized representatives of the company may be summoned to represent the company and prosecuted for the acts done by the company. The company itself may be fined or penalized as allowed under law. Key points of Section 305 applies when corporation or company is accused. Summons issued to authorized representatives. Officers may be held responsible for offences. Company can be fined or punished as per law. Ensures accountability of legal entities. Why this section is important. Makes companies and corporations legally accountable. Prevents abuse of legal personality to avoid punishment. Ensures offences committed by organizations are properly addressed. Protects public and commercial interests. In short, Section 305 provides that when a company or corporation is accused, the court summons its authorized representatives, and the company may be fined or held responsible for its officers' actions. Section 306, Procedure for accused who is insane or mentally incapable. What this section is about. Section 306 explains how the court should deal with an accused person who is insane or mentally incapable of defending himself during criminal proceedings. In simple English, if an accused person appears to be insane or mentally incapable of understanding the proceedings, then the court may order an examination by a medical officer or psychiatrist to assess mental capacity. If the person is found mentally unfit to stand trial, the court may postpone the trial or take special measures for his protection. The accused cannot be punished while incapable of understanding the proceedings. Key points of Section 306 applies to accused who are insane or mentally incapable. Court may seek medical opinion. Trial may be postponed or modified. Protects the accused from unjust punishment. Ensures fairness in criminal justice. Why this section is important. Upholds principles of natural justice. Protects mentally ill or vulnerable accused. Ensures trial is fair and human. Prevents conviction of a person who cannot defend himself. In short, Section 306 provides that if an accused is insane or mentally incapable of defending himself, the court may order examination, postpone the trial, and ensure he is not punished unfairly. Section 307 Cases where the accused escapes or is absconding. What this section is about. Section 307 explains how a court should deal with an accused who is not present, either because he has escaped or is intentionally absconding. In simple English, if an accused escapes from custody or does not appear in court despite being summoned, then the court may proceed with the trial in his absence, trial in absentia, if allowed by law. The court may issue warrants for his arrest to bring him back. Any sentence or fine can be executed once he is apprehended, or in some cases, the court may impose sentence in absentia if legally permissible. Important consideration. The court must ensure that due process is followed. Trial in absentia is generally restricted to certain offences and requires statutory authority. Key points of Section 307 applies when accused escapes or is absent. Court may issue arrest warrants. Trial may continue in absentia where permitted. Sentence is enforceable once apprehended. Ensures accused cannot evade justice. Why this section is important. Prevents accused from escaping punishment. Maintains efficiency of criminal trials. Protects rights of the state and complainants. Balances fair trial with accountability. In short, Section 307 provides that if the accused escapes or is absent, the court may issue warrants and, where law permits, proceed with the trial in absentia, with sentence enforceable when apprehended. Section 308 Power to issue arrest warrant for accused absent on summons. What this section is about. Section 308 explains what a court can do when an accused fails to appear in court after being summoned. It allows the court to issue a warrant to bring the accused into custody. In simple English, if an accused is summoned to court and does not appear on the date fixed, then the magistrate or court may issue a warrant for his arrest. The warrant authorizes the police or other officers to take the accused into custody. The accused is then brought before the court to continue the trial. This ensures that the accused cannot avoid trial by ignoring summons. Key points of Section 308 applies when accused does not appear after summons. Court may issue an arrest warrant. Police or other authorized officers execute the warrant. Accused is brought before the court. Ensures participation in the trial. Why this section is important. Prevents accused from evading justice. Maintains orderly conduct of trials. Protects interests of complainant, victim, and society. balances right to be present with duty to appear in court. In short, Section 308 provides that if an accused fails to appear after summons, the court may issue a warrant for his arrest to bring him before the court. Section 309 Procedure when arrest warrant is issued. What this section is about. Section 309 explains what steps should be followed after the court issues an arrest warrant for an accused who has failed to appear. In simple English, when a court issues an arrest warrant, the police or authorized officer must take action to locate and arrest the accused. The accused must be brought before the court as soon as possible. Once produced, the court may continue the trial or take further steps like adjourning, issuing bail, or proceeding in absentia if law allows. The main goal is to ensure the accused faces trial and does not evade justice. Key points of Section 309 applies after warrant of arrest is issued. Police or authorized officer executes the warrant. Accused is brought before the court promptly. Court may continue the trial or take other appropriate steps. Ensures orderly administration of justice. Why this section is important. Prevents escape of accused. Ensures the trial can proceed. Maintains fairness for both prosecution and accused. Upholds rule of law. In short, Section 309 provides that when an arrest warrant is issued, the police or authorized officer must arrest the accused and produce him before the court for further proceedings. Section 310 Issue of proclamation for accused who absconds. What this section is about. Section 310 explains what the court can do if an accused deliberately absconds and cannot be brought to court even after issuing a warrant. In simple English, if an accused cannot be found or arrested and is deliberately avoiding trial, then the court may publish a proclamation ordering the accused to appear in court within a specified time. The proclamation is published publicly, often in newspapers or at the court notice board. If the accused fails to appear within the time, the court may proceed in absentia or take further legal steps, including attachment of property. Key points of Section 310 applies when accused absconds or cannot be arrested. Court issues a public proclamation. Specifies a time limit to appear. Enables trial to continue in absentia if the accused ignores it. Protects court proceedings from delays due to absconding. Why this section is important. Ensures trial is not indefinitely delayed. Allows courts to deal with habitual absconders. Protects rights of victims and prosecution. Balances fairness with effective administration of justice. In short, Section 310 provides that if an accused absconds, the court may issue a public proclamation requiring him to appear within a specified time, failing which the court may proceed with the trial. Section 311 Power to summon and examine witnesses. What this section is about. Section 311 gives the court the power to summon and examine witnesses at any stage of the trial, even if they were not originally called, to ensure justice is served. In simple English, during a trial, if the court believes that a witness not yet examined has information vital to the case, or a witness already examined needs to be recalled for further questioning, then the court may summon that witness and examine or re-examine them at any stage of the proceedings if it is necessary to discover the truth or to prevent miscarriage of justice. Key points of Section 311 applies at any stage of the trial. Court can summon new witnesses or recall old ones. Purpose: to serve justice and discover the truth. Court has discretionary power, but must act judicially. Ensures no miscarriage of justice due to absence of evidence. Why this section is important? Prevents conviction or acquittal based on incomplete evidence. Empowers courts to adapt proceedings to new facts. Protects the rights of accused and prosecution. Balances speed of trial with justice. In short, Section 311 empowers the court to summon and examine witnesses or recall them at any stage of the trial if it is necessary to ensure justice. Section 312, power to examine witnesses at instance of court or parties. What this section is about. Section 312 explains who can request the examination of witnesses in a criminal trial and gives the court discretion to allow it. In simple English, during a trial, the court itself may ask for a witness to be examined if it thinks it is necessary for justice. The parties to the case, prosecution or defense, may also request the court to summon and examine a witness. The court may then allow or refuse the request, based on whether it considers the examination necessary to discover the truth or to ensure a fair trial. Key points of Section 312. Both court and parties can request witness examination. Court has discretion to allow or refuse. Ensures trial proceeds based on relevant evidence. Prevents unnecessary or irrelevant witnesses. Focuses on fairness and truth-finding. Why this section is important. Gives parties and court flexibility to produce evidence. Ensures no key evidence is overlooked. Strengthens fair trial and justice delivery. Prevents miscarriage of justice due to missing witnesses. In short, Section 312 provides that witnesses may be examined at the instance of the court or of the parties, and the court may allow it if necessary to ensure a fair trial. Section 313, power to examine accused. What this section is about. Section 313 explains the procedure for questioning the accused by the court during a criminal trial. It ensures the accused has a chance to explain the evidence against him before conviction. In simple English, during a trial, if the court thinks that evidence against the accused is sufficient to consider conviction, then the court may examine the accused personally, ask questions about the evidence produced, and allow the accused to explain, deny, or admit facts. Key points. The accused does not have to answer, but silence cannot be used as proof of guilt. Purpose: to give the accused a fair chance to explain the case against him. To ensure no conviction happens without giving opportunity to be heard. Key points of Section 313. Applies to all trials where evidence is against the accused. Court may personally question the accused. Accused may deny, explain, or remain silent. Silence cannot be considered as admission of guilt. Ensures fair trial and natural justice. Why this section is important. Upholds principle of audi alteram partem, hear the other side. Prevents unjust conviction. Protects accused's fundamental rights. Ensures conviction only after giving a fair opportunity to explain. In short, Section 313 provides that the court may examine the accused regarding the evidence against him, and the accused may explain or deny the facts before the court decides on conviction. Section 314, power to record evidence of witnesses unable to attend in person. What this section is about. Section 314 provides the procedure to record the evidence of witnesses who cannot personally attend the court due to age, illness, or other valid reasons. In simple English, if a witness cannot appear in court due to sickness, age, or other sufficient reasons, then the court may allow the witness to give evidence from another place, such as via video link, or written deposition, or through another court or authority. The evidence recorded this way is treated as valid and admissible in the trial. Purpose: to ensure justice is not delayed, to protect vulnerable witnesses, to prevent loss of evidence due to absence. Key points of Section 314 applies when witnesses cannot attend personally. Court may record evidence by suitable alternative methods. Evidence is admissible in trial. Ensures fair trial and preservation of evidence. Especially useful for elderly, sick, or distant witnesses. Why this section is important: prevents trials from being delayed or obstructed. Ensures vital evidence is not lost. Protects rights of accused and witnesses. Enhances efficiency and fairness in criminal justice. In short, Section 314 provides that the court may record the evidence of witnesses unable to attend in person through alternative methods, and such evidence is valid for trial purposes. Section 315, power to administer oath or affirmation to witnesses. What this section is about: Section 315 explains that all witnesses giving evidence in a criminal trial must do so under oath or affirmation, ensuring the truthfulness and legality of their testimony. In simple English, every witness, before giving evidence, must be administered an oath, religious, or affirmation, secular, to tell the truth. This applies to all witnesses in criminal proceedings, whether examined by court or parties under Sections 311, 314. Purpose: to make the witness legally bound to speak the truth. To prevent false evidence or perjury. Key points of Section 315. All witnesses must take oath or affirmation. Applies to all stages of trial. Administered by court or authorized officer. Ensures truthful testimony. Protects against perjury and false evidence. Why this section is important: upholds integrity of evidence. Protects accused from false allegations. Ensures justice is based on reliable testimony. Reinforces legal obligations of witnesses. In short, Section 315 provides that all witnesses must be administered an oath or affirmation to tell the truth before giving evidence in a criminal trial. Section 316, power of court to examine witnesses outside the court. What this section is about: Section 316 explains that the court may examine witnesses outside the courtroom in special circumstances to ensure justice is served and evidence is not lost. In simple English, during a trial, if a witness cannot attend the court, or the court thinks it is necessary to examine a witness elsewhere, then the court may order the witness to be examined outside the courtroom, such as at the witness's residence, at a hospital, or at any other appropriate location. The evidence recorded is valid for the trial. Purpose: to ensure vital evidence is preserved. To accommodate witnesses who are sick, old, or otherwise unable to appear in court. Key points of Section 316. Applies when witnesses cannot personally attend court. Court may examine witnesses elsewhere. Evidence recorded is legally valid. Protects rights of both accused and witnesses. ensures justice is not delayed or denied. Why this section is important? Prevents loss of important testimony. Maintains speed and efficiency of trial. Balances convenience of witness with fairness to accused. Strengthens truth-finding function of trial. In short, Section 316 allows the court to examine witnesses outside the courtroom when necessary, and such evidence is valid for the trial. Section 317 Examination of persons confined or in custody. What this section is about? Section 317 provides the procedure for examining witnesses who are in prison, custody, or otherwise confined, so their evidence can be included in a trial without undue hardship. In simple English, if a witness is in jail or under police or other lawful custody, then the court may send an order to the authority in charge of the custody to produce the person for examination. Examine the witness in the place of confinement if it is inconvenient or unsafe to bring them to court. The evidence recorded in this way is valid for the trial, helps ensure that all relevant evidence is available. Key points of Section 317 applies to witnesses in custody or confined. Court can examine them in prison or place of confinement. Evidence is admissible and valid. Ensures no obstruction of justice. Protects the rights of the accused and witnesses. Why this section is important? Ensures prisoners or detained persons can give evidence. Prevents trials from being delayed due to custody issues. Helps in preserving vital testimony. Maintains fairness and efficiency in criminal proceedings. In short, Section 317 allows the court to examine witnesses who are confined or in custody, either by producing them or examining them where they are, and such evidence is valid for trial. Section 318 Adjournment of trial in certain cases when witness is absent. What this section is about? Section 318 explains what the court may do if a witness fails to appear for examination during a criminal trial, and whether the trial should be adjourned or proceed. In simple English, during a trial, if a witness fails to attend court without sufficient reason, the court may adjourn the trial to a later date, or proceed with the trial if the absence does not affect the fairness of the trial. The court must consider the importance of the witness and the reason for absence before deciding. Purpose: to ensure the trial does not get unnecessarily delayed. To balance speedy trial with justice and fairness. Key points of Section 318 applies when a witness is absent. Court may adjourn or proceed depending on circumstances. Must consider importance of witness and reason for absence. Ensures fair trial without unnecessary delay. Gives court discretion to act judicially. Why this section is important? Prevents manipulation by absconding witnesses. Ensures speedy justice. Maintains balance between fairness and efficiency. Protects rights of accused and prosecution. In short, Section 318 provides that if a witness is absent, the court may adjourn the trial or proceed after considering the importance of the witness and the reason for absence. Section 319 Examination of witnesses by video link or other electronic means. What this section is about. Section 319 provides that witnesses can be examined remotely using video conferencing or other electronic methods in criminal trials. This modern provision ensures justice is not delayed when witnesses cannot appear in person. In simple English, during a trial, if a witness cannot attend the court physically due to distance, health issues, or any other sufficient reason, then the court may allow the witness to give evidence through video link or other electronic means. Ensure the witness is able to see and hear the proceedings. Record the evidence as official and valid. Purpose: to facilitate participation of witnesses, to speed up the trial, to prevent loss of vital testimony. Key points of Section 319. Witness may be examined remotely. Applies when physical presence is not feasible. Evidence is valid and admissible. Court ensures fairness and ability to communicate. Modernizes criminal procedure for efficiency. Why this section is important. Prevents trials from being delayed due to absent witnesses. Protects rights of accused and prosecution. Uses technology to ensure access to justice. Ensures reliable evidence can be recorded without physical presence. In short, Section 319 allows witnesses to be examined through video link or other electronic means, and such evidence is valid for the trial. Section 320, compounding of offences. What this section is about. Section 320 explains which offences can be compounded, meaning the parties involved can settle the matter without going through full trial, usually through agreement between the victim and the accused. In simple English, certain offences can be settled privately if the law allows. These are usually less serious offences, e.g., minor hurt, defamation, or petty property offences. Compounding is permitted only for offences listed in Section 320, such as hurt or voluntarily causing minor injury, wrongful restraint, defamation, etc. Victim's consent is mandatory, and if the offense is compoundable, the court can discharge the accused once settlement is recorded. Some offences require court approval even after the victim agrees. Purpose: to reduce the burden on courts, to promote reconciliation between parties, to save time and resources. Key points of Section 320. Only certain compoundable offences as listed are eligible. Requires victim's consent. Court may record the settlement and discharge accused. Serious offences cannot be compounded without state consent. Helps in speedy disposal of cases. Why this section is important. Encourages amicable settlement of minor disputes. Reduces court backlog. Promotes reconciliation and restorative justice. Ensures lawful and structured settlement. In short, Section 320 provides a list of offences which can be compounded, allowing the victim and accused to settle the matter with court approval if required for certain minor offences. Section 321, cognizance of offences by magistrates. What this section is about. Section 321 explains how and when a magistrate can take notice, cognizance of an offence and start legal proceedings. In simple English, a magistrate can take cognizance of an offence on receiving a complaint from a person or a public authority, or upon receiving a police report, or when the magistrate otherwise knows of the offence, e.g., witnesses appear or evidence is presented. Once the magistrate takes cognizance, he may direct investigation, issue summons or warrants, and begin trial according to the procedure of law. Purpose: to ensure that criminal proceedings begin lawfully and magistrates act on proper information. Key points of Section 321 applies to all offences triable by magistrates. Cognizance can arise from complaint, police report, or other sources. Magistrate decides whether proceedings should start. Provides a legal basis for investigation or trial. Why this section is important. Ensures magistrates act lawfully in taking notice of crimes. Prevents arbitrary initiation of proceedings. Maintains legal procedure and fairness. Serves as the starting point of a criminal case. In short, Section 321 provides that a magistrate can take cognizance of an offence on a complaint, police report, or other information and can then initiate legal proceedings. Section 322 Complaints to magistrates. What this section is about. Section 322 explains how a person can make a complaint to a magistrate regarding the commission of an offence. In simple English, any person who wants to report an offence may approach a magistrate with a written or oral complaint. The complaint must include facts of the offence, details of the accused, and other relevant information to help the magistrate understand the case. Once the complaint is made, the magistrate may record the complaint, take cognizance of the offence, and initiate proceedings according to law. Purpose: to allow citizens to bring offences to the notice of the court. To provide a legal pathway for complaints without going through the police first for certain offences. Key points of Section 322. Complaints can be written or oral. Must provide sufficient details about the offence and accused. Magistrate may record the complaint and take cognizance. Provides a direct route to initiate proceedings. Why this section is important. Empowers citizens to report offences. Ensures magistrates can act promptly. Protects public interest and promotes access to justice. Allows initiation of proceedings even without police involvement in certain cases. In short, Section 322 allows any person to make a complaint to a magistrate about an offence, and the magistrate may record the complaint and take cognizance to start proceedings. Section 323 Cognizance of offences by magistrates upon police reports. What this section is about. Section 323 explains how magistrate takes cognizance of an offence when a police report, FIR or charge sheet is submitted. In simple English, when a police report, FIR or investigation report is submitted to a magistrate, the magistrate may take cognizance of the offence and proceed with the case according to law. The magistrate may direct further investigation if needed before beginning the trial. Purpose: to provide a legal framework for starting proceedings based on police investigations. To ensure the magistrate reviews and approves action before trial begins. Key points of Section 323. Applies when a police report is submitted. Magistrate may take cognizance and start proceedings. Magistrate may require further investigation. Provides judicial oversight of police actions. Why this section is important. Ensures magistrates supervise police proceedings. Prevents automatic trial without judicial review. Balances investigative authority with judicial control. Protects the rights of accused and public interest. In short, Section 323 provides that a magistrate may take cognizance of an offence on receiving a police report and may direct further investigation or begin proceedings. Section 324, Process for committing cases to Sessions Court. What this section is about. Section 324 explains how cases are sent from a magistrate to a sessions court for trial when the offence is beyond the magistrate's jurisdiction. In simple English, certain offences are too serious for a magistrate to try, e.g., murder, serious robbery. When such a case arises, the magistrate must prepare the case record, including all evidence, statements, and police reports. Commit the case to the Sessions Court with a formal report. Sessions Court then takes cognizance and begins trial. Purpose: ensures serious offences are tried by competent courts. Maintains proper hierarchy in criminal justice. Key points of Section 324 applies to offences beyond magistrate's trial jurisdiction. Magistrate prepares complete case record. Case is formally sent to Sessions Court. Ensures trial in appropriate court. Why this section is important. Prevents magistrates from trying offences beyond their power. Ensures fair trial by appropriate authority. Maintains judicial hierarchy and procedural correctness. Protects rights of accused and victims. In short, Section 324 provides that when an offence is beyond a magistrate's jurisdiction, the magistrate must commit the case to the Sessions Court with all relevant records for trial. Section 325, Filing of charges and framing by the court. What this section is about. Section 325 explains how the court formally frames charges against an accused once a case is before it, setting the foundation for the trial. In simple English, after a case reaches the court, magistrate or sessions court, the court must examine the police report, evidence, and complaint. Decide if there is sufficient ground to proceed with a trial. Formally frame charges against the accused. The accused is then required to plead guilty or not guilty. Trial proceeds only on the charges framed. Purpose: clearly defines what the accused is being tried for. Prevents trial on vague or unsupported allegations. Key points of Section 325. Court reviews evidence before framing charges. Charges must be clear and specific. Accused is informed and asked to plead. Trial proceeds only on framed charges. Why this section is important. Protects accused from being tried arbitrarily. Ensures due process and fair trial. Maintains clarity and focus in trial proceedings. Avoids trial on unsubstantiated claims. In short, Section 325 provides that the court must examine the case, frame clear charges against the accused, and require a plea before starting the trial. Section 326, Trial of warrant cases by magistrate. What this section is about. Section 326 explains how magistrates conduct trials for warrant cases, which are more serious offences requiring formal trial. In simple English, warrant cases are offences punishable with imprisonment of more than 2 years or otherwise requiring formal judicial trial. The magistrate reads and explains the charges to the accused. Conducts the trial by examining prosecution witnesses, allowing cross-examination, examining the accused's defense, records evidence and proceedings properly, delivers judgment based on evidence. Purpose: to provide a structured process for serious offences. Ensures accused gets a fair trial. Key points of Section 326. Applies to warrant cases, serious offences. Magistrate frames charges and conducts trial. Witnesses are examined and cross-examination allowed. Accused may present defense and evidence. Court delivers judgment based on evidence. Why this section is important? Ensures fair, thorough trial for serious offences. Maintains procedure and accountability in magistrate courts. Protects rights of accused and public interest. Avoids arbitrary conviction or unfair trial. In short, Section 326 provides that magistrates must conduct a structured trial for warrant cases, including examining witnesses, recording evidence, hearing the defense, and delivering judgment. Section 327 Commencement of Trial in Summons Cases. What this section is about. Section 327 explains how trials for summons cases, less serious offences, begin and proceed in court. In simple English, summons cases are offences punishable with imprisonment of up to 2 years, fine, or both. Procedure for starting a trial. Court issues summons to the accused. Accused appears in court on the date fixed. Charges are read and explained to the accused. Accused is asked to plead guilty or not guilty. Trial proceeds by examining prosecution witnesses, allowing cross-examination, and hearing defense evidence. Purpose: to provide a simpler and quicker trial process for minor offences. Key points of Section 327 applies to summons cases, minor offences. Charges are read and explained. Accused pleads guilty or not guilty. Prosecution and defense evidence are examined. Trial is simpler than warrant cases. Why this section is important? Ensures minor offences are dealt with quickly. Protects rights of accused to be heard. Maintains efficiency and fairness in the judicial process. Distinguishes procedure for minor versus serious offences. In short, Section 327 provides that trials in summons cases begin by serving summons, explaining charges, hearing the plea of the accused, and examining witnesses in a simpler procedure than warrant cases. Section 328 Framing of charges in warrant cases by magistrate. What this section is about. Section 328 explains how a magistrate formally frames charges in warrant cases before starting the trial, ensuring the accused knows exactly what they are being tried for. In simple English, in a warrant case, serious offense, the magistrate examines the police report, evidence, and complaint. If there is enough ground to proceed, the magistrate frames specific charges against the accused and reads and explains the charges to the accused. The accused is then asked to plead guilty or not guilty. Purpose: to clarify the allegations. To ensure the accused can prepare their defense properly. To prevent trial on vague or unsupported accusations. Key points of Section 328 applies to warrant cases. Magistrate examines evidence before framing charges. Charges must be clear and specific. Accused is required to plead. Trial proceeds only on the framed charges. Why this section is important? Protects rights of accused. Maintains clarity and fairness in trial. Prevents arbitrary or vague charges. Ensures trial focuses only on supported allegations. In short, Section 328 provides that in warrant cases, the magistrate must examine the evidence, frame clear charges, explain them to the accused, and seek a plea before starting the trial. Section 329 Trial of warrant cases by magistrate. What this section is about. Section 329 explains how magistrate conducts a trial in warrant cases, including the steps to examine evidence and hear the defense before delivering a judgment. In simple English, a warrant case is a serious offense that requires formal trial. The magistrate, after framing charges, reads the charges to the accused, examines prosecution witnesses and allows cross-examination, allows the accused to present evidence and defense, records all evidence and proceedings, finally, delivers judgment based on the evidence and arguments. Purpose: to provide a structured, fair, and transparent trial process for serious offences. Key points of Section 329 applies to warrant cases, serious offences. Court conducts examination of witnesses and cross-examination. Accused is allowed to present defense. Evidence and proceedings are formally recorded. Judgment is delivered after proper trial. Why this section is important. Ensures fair trial for serious offences. Prevents arbitrary convictions. Maintains order and transparency in magistrate trials. Protects rights of accused and public interest. In short, Section 329 provides that magistrates must conduct a proper trial for warrant cases, including examining witnesses, recording evidence, hearing the defense, and delivering judgment. Section 330 Trial of Summons Cases by Magistrate. What this section is about. Section 330 explains how magistrate conducts a trial in summons cases, which are less serious offences punishable with imprisonment up to 2 years, fine, or both. In simple English, in a summons case, the magistrate issues summons to the accused. On appearance, the charges are read and explained. The accused is asked to plead guilty or not guilty. If not guilty, the trial proceeds. Examination of prosecution witnesses. Cross-examination. Evidence by the accused, if any. After hearing both sides, the magistrate delivers judgment. Purpose: to provide a simpler and faster trial procedure for minor offences. Key points of Section 330 applies to summons cases, minor offences. Charges are read and explained to accused. Accused may plead guilty or not guilty. Evidence is examined and cross-examined. Trial is simpler than warrant cases. Why this section is important. Ensures speedy disposal of minor offences. Protects rights of accused to be heard. Maintains efficiency in judicial process. Distinguishes procedure for minor versus serious offences. In short, Section 330 provides that in summons cases, the magistrate conducts a simplified trial including issuing summons, explaining charges, examining witnesses, and delivering judgment. Section 331 Power of court to dispense with personal attendance of accused in certain cases. What this section is about. Section 331 allows the court to not require the accused to appear personally in minor cases, particularly summons cases, under certain conditions. In simple English, if the court considers it unnecessary for the accused to be physically present, it may proceed with the trial or allow the accused to be represented by a pleader. This usually applies to summons cases, minor offences, situations where the accused's presence is not essential. Purpose: to speed up trials, to reduce inconvenience for the accused, to ensure minor cases are resolved efficiently. Key points of Section 330. Applies mostly to summons cases. Court may dispense with personal appearance. Accused may be represented by lawyer. Speeds up minor trials. Reduces unnecessary delay and burden. Why this section is important? Promotes efficiency in minor cases. Reduces court congestion. Prevents inconvenience to accused. Maintains fairness while simplifying procedure. In short, Section 331 allows the court to proceed with trial or have the accused represented by a lawyer without requiring the accused's personal appearance in certain minor cases. Section 332 Trial of summons cases where personal attendance of accused is dispensed with. What this section is about. Section 332 explains how a trial proceeds in summons cases when the accused is not personally present, as allowed under Section 331. In simple English, when personal attendance of the accused is dispensed with, the trial continues with the accused being represented by a pleader or even in absentia if law permits. The court can examine prosecution witnesses, allow cross-examination, record defense evidence submitted through lawyer. After considering the evidence, the court delivers judgment. Purpose: to ensure minor cases are tried efficiently. To allow legal representation without unnecessary delay. Key points of Section 332. Applies when accused's personal attendance is dispensed. Accused may be represented by pleader. Trial proceeds in absentia or via representation. Evidence is examined and judgment is delivered normally. Speeds up minor case trials. Why this section is important. Maintains fair trial while simplifying procedure. Reduces court congestion. Protects rights of accused via lawyer representation. Ensures efficient justice for minor offences. In short, Section 332 provides that when an accused's personal appearance is dispensed within a summons case, the trial may proceed through representation with witnesses examined and judgment delivered as usual. Section 333 Framing of additional charges during trial. What this section is about. Section 333 explains how the court may frame additional charges against the accused if, during the trial, it finds evidence of another offense related to the same facts. In simple English, during a trial, if the court discovers evidence suggesting the accused committed another offense, the court may frame new charges based on the additional evidence. The accused is then asked to plead guilty or not guilty to these additional charges. The trial continues with the additional charges along with the original ones. Purpose: to ensure all offences discovered during the trial are addressed. To prevent the accused from escaping liability for related offences. Key points of Section 333. Applies when new offence is discovered during trial. Court may frame additional charges. Accused must be informed and asked to plead. Trial continues including new charges. Ensures comprehensive justice. Why this section is important. Prevents accused from avoiding responsibility for related offences. Maintains efficiency by handling multiple charges in one trial. Upholds fairness and completeness of criminal justice. Protects rights of victims and society. In short, Section 333 allows the court to frame additional charges during trial if new evidence indicates the accused committed another offense and the accused is asked to plead to the new charges. Section 334 Withdrawal of complaint in cases where compounding is allowed. What this section is about. Section 334 explains how a complaint can be withdrawn in cases where the offence is compoundable, i.e., the victim and accused can settle the matter amicably. In simple English, if the offense is compoundable under Section 320, the complainant may withdraw the complaint before the trial or even during trial. The magistrate must record the withdrawal formally. Once the complaint is withdrawn, the case against the accused may be dismissed. Purpose: to allow settlement in minor offences, to reduce court burden and promote reconciliation. Key points of Section 334 applies only to compoundable offences. Complainant may withdraw complaint. Court must formally record the withdrawal. Case may be dismissed after withdrawal. Promotes settlement and restorative justice. Why this section is important: encourages amicable resolution of minor disputes, reduces court congestion, protects rights of accused in minor offences, helps achieve speedy justice and reconciliation. In short, Section 334 provides that in compoundable offences, the complainant may withdraw the complaint, and the court may dismiss the case after formally recording the withdrawal. Section 335, power of court to release accused on bail in certain cases. What this section is about: Section 335 explains when and how a court may release an accused on bail while ensuring the trial or investigation can proceed fairly. In simple English, in certain cases, the court may release the accused on bail, i.e., allow them to remain free pending trial, if the offense is not very serious, or the accused is unlikely to flee, and the interests of justice are not harmed. The court may impose conditions for bail, such as surety, regular appearance in court, or restriction on travel. Purpose: to balance the rights of the accused with the need for justice, to prevent unnecessary detention before conviction. Key points of Section 335 applies to certain offences or circumstances. Court may grant bail at its discretion. Bail may include conditions or surety. Protects rights of accused pending trial. Ensures trial proceeds fairly. Why this section is important: prevents unjust pretrial detention. Balances fair trial and public interest. Reduces overcrowding in prisons. Provides legal mechanism to secure attendance of accused. In short, Section 335 allows the court to release the accused on bail in certain cases with or without conditions to ensure fairness and justice while the trial or investigation proceeds. Section 336, cognizance of offences committed in the presence of a magistrate. What this section is about: Section 336 explains how a magistrate can take immediate cognizance when an offence is committed directly in front of them. In simple English, if an offence is committed in the presence of a magistrate, such as assault, public nuisance, or any other criminal act, then the magistrate may take cognizance immediately without waiting for a complaint or police report. The magistrate can arrest the offender on the spot if necessary. Proceedings can begin immediately, ensuring swift justice. Purpose: to deal with offences instantly. To prevent delay and protect public order. Key points of Section 336 applies when offence is committed in presence of magistrate. Magistrate may take immediate cognizance. Magistrate can arrest the offender on the spot. Ensures swift legal action. Does not require police report or prior complaint. Why this section is important: enables prompt action against offenders. protects public safety and order, ensures efficient administration of justice, prevents offenders from escaping immediate legal consequences. In short, Section 336 allows a magistrate to take cognizance and begin proceedings immediately if an offence is committed in their presence, including arresting the offender if necessary. Section 337, causing hurt by act endangering life or personal safety of others. What this section is about. Section 337 deals with liability for causing hurt or injury to someone when the act endangers the life or personal safety of others, even if the hurt is not fatal. In simple English, if a person performs an act that is dangerous to human life or could cause injury to someone, and as a result, someone gets hurt, then the offender can be held criminally responsible. The injury may be minor, but caused due to negligence or recklessness. The punishment is less severe than causing grievous hurt, but legal action can still be taken. Purpose: to protect people from reckless or negligent acts. To ensure accountability for endangering others. Key points of Section 337 applies to acts endangering life or personal safety. Even minor injuries make offender liable. Offense is usually punishable with fine or imprisonment. Focus is on recklessness or negligence. Why this section is important. Protects public from careless or dangerous actions. Encourages responsible behavior. Holds people accountable even if injuries are not fatal. Supports safety and preventive justice. In short, Section 337 provides that anyone causing hurt to another person by performing an act that endangers life or personal safety is liable for criminal action, even if the injury is minor. Section 338, causing grievous hurt by act endangering life or personal safety of others. What this section is about. Section 338 deals with cases where an act endangers life or personal safety of others and results in grievous hurt, which is more serious than minor hurt under Section 337. In simple English, if a person performs an act that is dangerous to human life or could cause serious injury, and as a result, someone suffers grievous hurt, e.g., broken bones, permanent injury, or disfigurement, then the offender is criminally liable. The punishment is more severe than for minor hurt, often including imprisonment or heavy fine. This applies even if the injury was accidental, but caused due to recklessness or gross negligence. Purpose: to deter reckless acts that can seriously injure others. To ensure accountability for causing serious harm. Key points of Section 337 applies to grievous hurt caused by dangerous acts. Act must endanger life or personal safety. Punishment is more severe than for minor hurt. Covers recklessness or gross negligence. Why this section is important. Protects public from serious injury due to negligent acts. Ensures strict accountability. Encourages responsible conduct in potentially dangerous situations. Distinguishes minor versus grievous hurt legally. In short, Section 338 provides that anyone causing grievous hurt by performing an act that endangers life or personal safety is liable for more severe criminal punishment. Section 339 acts endangering life or personal safety of others, presumption of intent. What this section is about. Section 339 explains that when someone commits an act dangerous to life or personal safety, the law may presume intent or knowledge of danger, making it easier to hold them accountable. In simple English, if a person performs an act that is obviously dangerous to human life or safety and it causes hurt or grievous hurt, then the court may presume that the person intended the consequence or knew it was likely to occur. The accused may still defend themselves, but the burden shifts slightly since intent or knowledge is presumed. Purpose: to hold people accountable for dangerous acts, to prevent offenders from escaping liability by claiming no intent. Key points of Section 339 applies to acts endangering life or safety. Court may presume knowledge or intent. Presumption is rebuttable. Accused can prove otherwise. Focuses on public safety and accountability. Why this section is important. Strengthens legal protection for public. Ensures reckless or dangerous acts are punished. Makes it difficult for offenders to escape responsibility. Encourages careful and responsible conduct. In short, Section 339 provides that if a person does an act endangering life or safety, the court may presume they intended or knew the risk, though this presumption can be rebutted. Section 340, Police Report of Certain Offences, Investigation by Magistrate. What this section is about. Section 340 explains how certain offences are investigated directly by magistrate instead of the police, especially in cases involving public interest or serious matters. In simple English, for certain offences, like defamation, offences against the state or public servants, the law allows the magistrate to conduct the investigation instead of the police. Procedure: complaint or information is submitted to the magistrate. The magistrate may direct investigation or inquiry personally. Based on findings, the magistrate may take cognizance, issue summons, or proceed with trial. Purpose: to ensure impartial and direct investigation in sensitive cases. To protect public interest and justice. Key points of Section 340 applies to certain sensitive offences. Investigation is directed by magistrate, not police. Magistrate can take cognizance after inquiry. Protects public interest and fairness. Ensures proper legal procedure in sensitive matters. Why this section is important. Ensures impartial investigation in special cases. Protects victims and public servants. Prevents influence or bias in police investigations. Upholds rule of law and accountability. In short, Section 340 provides that in certain offences, the magistrate can directly investigate the matter, take cognizance, and proceed with the trial, ensuring impartiality and protection of public interest. Section 341, Punishment for Wrongful Restraint. What this section is about. Section 341 defines what constitutes wrongful restraint and prescribes the punishment for it. In simple English, wrongful restraint occurs when someone prevents another person from moving freely in a place where they have a right to go. Example: blocking someone's path, stopping them from entering their own property, or preventing them from leaving a public place. Punishment: imprisonment up to 1 month, or fine up to 500 rupees, or both. Purpose: to protect personal liberty, to prevent harassment or obstruction of movement. Key points of Section 341. Focuses on unlawful obstruction of free movement. Does not involve physical harm, that's wrongful confinement or assault. Punishable by short imprisonment or fine. Ensures personal liberty and safety. Why this section is important. protects freedom of movement, a fundamental right, prevents intimidation or harassment in public or private spaces, provides legal remedy for wrongful restraint. In short, Section 341 provides that anyone who wrongfully restrains another person from moving freely can be punished with imprisonment up to 1 month, a fine, or both. Section 342 Punishment for wrongful confinement. What this section is about. Section 342 defines wrongful confinement and prescribes the punishment for unlawfully restricting someone's freedom of movement within certain limits. In simple English, wrongful confinement occurs when someone unlawfully confines another person in a room, house, or any other place, restricting their freedom to move. Example: locking someone in a room or keeping them confined against their will. Punishment: imprisonment up to 1 year, or fine, or both. Purpose: to protect personal liberty, to prevent abuse, harassment, or illegal detention. Key points of Section 342. Applies to unlawful confinement. Differs from wrongful restraint, Section 341, because it involves keeping someone in a place. Punishable with imprisonment, fine, or both. Ensures personal freedom and safety. Why this section is important. Safeguards fundamental right to liberty. Provides legal protection against kidnapping or illegal detention. Ensures offenders are punished for unlawfully restricting freedom. In short, Section 342 provides that anyone who wrongfully confines another person can be punished with imprisonment up to 1 year, a fine, or both. Section 343 Punishment for wrongful confinement of women. What this section is about. Section 343 prescribes stricter punishment for anyone who wrongfully confines a woman, recognizing the vulnerability and special protection afforded to women under the law. In simple English, if someone unlawfully confines a woman, for example, locks her in a room, house, or building, prevents her from leaving a place against her will, then punishment: imprisonment up to 2 years, or fine, or both. Purpose: to provide greater protection to women, to deter acts that restrict liberty of women unlawfully. Key points of Section 343. Applies specifically to women. Involves wrongful confinement. Punishable with up to 2 years imprisonment, fine, or both. Stricter than Section 342 for general confinement. Protects personal liberty and safety of women. Why this section is important. Recognizes special vulnerability of women. Ensures strict legal consequences for offenders. Prevents abuse, harassment, or exploitation. Strengthens gender justice and protection under law. In short, Section 343 provides that anyone who wrongfully confines a woman can be punished with imprisonment up to 2 years, a fine, or both. Section 344 Punishment for wrongful confinement of a person for extortion. What this section is about. Section 344 deals with wrongful confinement committed with the intention of extorting property, money, or valuable things from a person. In simple English, if a person wrongfully confines someone with the purpose of forcing them to give money, property, or valuables, then punishment: imprisonment up to 3 years, or fine, or both. Purpose: to prevent use of confinement as a means of extortion, to ensure serious legal consequences for such criminal acts. Key points of Section 344 applies when confinement is for extortion purposes. Stronger punishment than general confinement. Section 342. Offender may face imprisonment up to 3 years, fine, or both. Protects victims' property and personal liberty. Why this section is important? Deters criminals from using illegal detention to extort. Protects public from coercion and threats. Strengthens law against kidnapping extortion. Ensures justice for victims of such crimes. In short, Section 344 provides that anyone who wrongfully confines a person for extortion can be punished with imprisonment up to 3 years, a fine, or both. Section 345. Punishment for wrongful confinement of a person with intent to commit an offence. What this section is about? Section 345 deals with wrongful confinement when the intention is to commit a further offence, such as robbery, assault, or theft during the confinement. In simple English, if a person wrongfully confines someone and does so with the intention to commit another crime, for example, robbery or assault, then punishment, imprisonment up to 7 years, and fine. Purpose: to deter offenders from using confinement as a tool to commit additional crimes. To impose harsher punishment for more dangerous acts. Key points of Section 345 applies when confinement is coupled with intent to commit another offence. Punishment is more severe than general confinement. Sections 342-344. Offender may face imprisonment up to 7 years and fine. Protects victims' liberty and safety. Why this section is important? Strong deterrent against confinement used to commit further crimes. Ensures serious consequences for offenders with criminal intent. Protects personal liberty, property, and safety of victims. Supports public order and criminal accountability. In short, Section 345 provides that anyone who wrongfully confines a person with the intent to commit another offence can be punished with imprisonment up to 7 years and a fine. Section 346. Punishment for wrongful confinement to extort property or money from a public servant. What this section is about? Section 346 deals with wrongful confinement, specifically targeting public servants in order to extort money, property, or other benefits. In simple English, if a person wrongfully confines a public servant, like a government employee, to force them to give money or obtain property or favors, then punishment, imprisonment up to 7 years, and fine. Purpose: to protect public servants from coercion or extortion. To safeguard integrity and smooth functioning of public administration. Key points of Section 346. Applies when victim is a public servant. Act must involve extortion or coercion. Punishment: imprisonment up to 7 years and fine. Stronger protection than general wrongful confinement. Prevents interference with official duties. Why this section is important? Protects government officials from harassment. Ensures public servants can perform duties safely. Deters criminals from using confinement to extract benefits. Maintains law and order in public service. In short, Section 346 provides that anyone who wrongfully confines a public servant to extort money or property can be punished with imprisonment up to 7 years and a fine. Section 347, punishment for wrongful confinement with intent to commit grievous hurt, robbery, or rape. What this section is about. Section 347 deals with wrongful confinement carried out with the intention of committing serious offences such as grievous hurt, robbery, or rape. In simple English, if a person wrongfully confines another person and intends to cause grievous hurt, or commit robbery, or commit rape, then punishment, imprisonment up to 10 years and fine. Purpose: to deter use of confinement to facilitate serious crimes. To impose severe punishment due to high risk and harm. Key points of Section 347 applies when confinement is for serious criminal intent. Punishment is more severe than ordinary confinement. Covers offences like grievous hurt, robbery, or rape. Protects personal liberty and bodily integrity. Why this section is important. Provides strong deterrent against using confinement for major crimes. Protects victims from severe physical and financial harm. Upholds public safety and law enforcement. Ensures justice is proportionate to the gravity of the intended offence. In short, Section 347 provides that anyone who wrongfully confines another with intent to commit grievous hurt, robbery, or rape can be punished with imprisonment up to 10 years and a fine. Section 348, wrongful confinement by secret means. What this section is about. Section 348 deals with wrongful confinement that is carried out secretly, meaning the victim is confined without their knowledge or awareness of being restrained. In simple English, if a person confines someone secretly, for example, locks them in a room when they are unaware, or hides them somewhere without their consent, then punishment, imprisonment up to 3 years and fine. Purpose: to protect personal liberty even when the victim is unaware at first. To prevent covert acts of confinement that could later facilitate crime. Key points of Section 348 applies to secret confinement. Victim may not initially know they are restrained. Punishable with imprisonment up to 3 years and fine. Focuses on protection of liberty and safety. Why this section is important. Protects personal freedom even in covert situations. Deters offenders from secretly restraining victims. Ensures early legal intervention before further harm occurs. Supports public safety and criminal accountability. In short, Section 348 provides that anyone who wrongfully confines a person secretly can be punished with imprisonment up to 3 years and a fine. Section 349, wrongful confinement for property or other benefits. What this section is about. Section 349 deals with wrongful confinement carried out to force someone to give property, money, or other benefits. In simple English, if a person wrongfully confines another person with the purpose of extorting money or property, or obtaining any other benefit, then punishment, imprisonment up to 7 years and fine. Purpose: to prevent offenders from using confinement to gain property or benefits. To ensure severe punishment for serious coercive acts. Key points of Section 349 applies when confinement is linked to extortion or gain. punishable with up to 7 years imprisonment and fine. Protects personal liberty and property rights. Stronger penalty than general confinement. Section 342. Why this section is important? Deters criminals from coercing victims for gain. Protects victims' property and liberty. Ensures justice is proportionate to the seriousness of the act. In short, Section 349 provides that anyone who wrongfully confines a person to extort property or other benefits can be punished with imprisonment up to 7 years and a fine. Section 350, wrongful confinement with intent to commit other offences. What this section is about? Section 350 deals with cases where a person wrongfully confines someone with the intention of committing another offence, such as robbery, grievous hurt, or rape. In simple English, if a person confines another person unlawfully, and the confinement is done with the purpose of committing another crime, then punishment, imprisonment up to 10 years, and fine. Purpose: to punish more severely when confinement is used to commit serious crimes. To deter offenders from using confinement as a tool for other criminal acts. Key points of Section 350. Applies when confinement is combined with intent to commit another offence. Covers offences like robbery, grievous hurt, or rape. Punishable with imprisonment up to 10 years and fine. Stronger penalty than general confinement, Sections 342, 349. Why this section is important? Provides strong deterrent for offenders. Protects victims from compounded criminal acts. Ensures punishment matches the severity of intent and action. Strengthens personal safety and public order. In short, Section 350 provides that anyone who wrongfully confines a person with the intent to commit another offence can be punished with imprisonment up to 10 years and a fine. Section 351, wrongful confinement of a public servant with intent to commit an offence. What this section is about? Section 351 deals with wrongful confinement, specifically targeting public servants when the confinement is done with the intent to commit an offence. In simple English, if a person wrongfully confines a public servant and does so intending to commit an offence such as robbery, assault, or